Okay, we are just about ready. Going to give another minute or two for all of the participants to join us. Okay, the time is 3:30, and I would like to thank you all and welcome you to the Office of Open Government's final installment of Ethics Week. I'm Chief Counsel Neal of the Office of Open Government. As you noted earlier, today is the Office of Open Government's opportunity to participate in Ethics Week. You heard earlier from our director this morning as she spoke about FOIA and the Open Meetings Act introduction. Then our FOIA officer, Anthony Skirbo, gave you an overview of FOIA. Brandon Lewis, one of our newest attorneys, gave us a newcomer's guide to the Open Meetings Act. And our former colleague, Nicholas Weil, gave us a parliamentary procedure lesson there, which was extremely interesting. But in addition to everyone who's participated, I also want to acknowledge our attorney advisor, Joan Lelma, who did not present, but who was extremely helpful in checking our work and making sure we were on track, and particularly me. And so very much appreciated. And also our paralegal, Kimberly Brown, who's also very helpful and very instrumental in helping us prepare and get ourselves together and getting us ready to do this. And of course, our Kevin Brown, who's our IT person who makes sure everything goes off without a hitch. So thank you to all of those folks, and thank you for everyone who's participated so far in all the presentations that have been absolutely fantastic. So my presentation today is Open Meetings Act and Freedom of Information Act advisory opinions that have been rendered. So all of the stuff that you've heard so far has given you some idea of what Open Meetings Act is, what FOIA is, obviously what parliamentary procedure is. So now my job is to try to bring it together in a practical way to give you some information about some of the advisory opinions, some of the recent advisory opinions that our director has issued. So having said that, let's begin. So just to reiterate some of the things that have already been said to you, the Office of Open Government is one of the components under BEGA. It's overseen by our Director Neal Allen, who you heard from this morning. OOG interprets and monitors compliance with the Open Meetings Act, which requires that public bodies provide proper notice of and access to detailed records of their meetings. And also the Freedom of Information Act, which concerns transparency and the availability of public records. Now, OOG provides guidance, including formal advisory opinions, which is what I'm going to be speaking about today, to public bodies in compliance with the OMA. OOG also conducts training and outreach and also enforces the OMA on the basis of complaints from the public and its own investigation. And as a last resort, OOG actually has the power and the authority to sue public bodies in the Superior Court for injunction, declaration, and civil fines. So the Director of Open Government under this particular statute has the authority and the power to issue advisory opinions under this particular law as it relates to the Open Meetings Act. That authority also says that the public body may seek an advisory opinion from the Office of Open Government regarding compliance with this particular subchapter. And this particular section, the Office of Open Government may issue advisory opinions on the implementation of Subchapter 2 of Chapter 5 regarding the DC Freedom of Information Act. And our presentation would not be complete without stating our public policy, also known as our preamble. The director reads this at every report before the BEGA board, and that is the public policy of the District of Columbia is that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and as employees. And we believe that is important. Each and every person in our office takes what we do very seriously. I think we're probably living in a time where the confidence in our government is probably at the lowest point it has ever been. So part of our duty is to help public bodies and agencies or whoever comes to us to do things right, to have a strong sense and a strong display of transparency. And so that is what we do, and we try to do our best at it. And this preamble pretty much embodies and encompasses what our mission is. So I'm going to discuss today 4 cases, 2 FOIA cases and 2 Open Meetings Act cases. One of the cases is Metropolitan Police Department regarding body-worn camera footage. That is a FOIA case. Another is a deputy mayor for planning and economic development. That is also a FOIA case where there was a denial of public records request. One of our Open Meetings Act advisory opinions is Aston Community Advisory Team, and a dismissal of a complaint. So not everything that comes to us actually gets a full-blown formal advisory opinion. Sometimes there are dismissals. So I'm going to start with the Metropolitan Police Department body-worn camera footage under the Freedom of Information Act. This case arose when the Metropolitan Police Department applied one of FOIA's exemptions. As you heard earlier from Anthony Skirbo, the federal FOIA has 9 exemptions, I believe it is. The District of Columbia has 21. So there are a lot of exemptions to the District of Columbia FOIA laws. Metropolitan Police Department decided to apply exemption number 2 to a heavily redacted body-worn camera footage of an accident scene where a driver hit the requester while the requester was crossing a street in DC. So the requester wanted us to determine whether the Metropolitan Police Department had a properly applied exemption 2 of the FOIA in denying the request for public records relating to that traffic accident, including any unredacted audio or video cameras of the body-worn cameras of the police department. Now, as I said, District of Columbia has 21 exemptions. Exemption number 2 is under this particular code, DC Official Code Section 2-534. And basically, it exempts information of a personal nature where the public disclosure would constitute a clearly unwarranted invasion of a person's personal privacy. This is the exemption that the District of Columbia or MPD used in excluding some of the information, some of the voice information, and some of the video footage of the camera that the requester had requested. But in addition to exemption 2, MPD also applied another rationale for not releasing the information. They said that without authorization and or privacy waiver on file from the individuals who could be seen and heard in the video footage, they would have to redact images of the voices to protect their privacies. And they also added that images of and badges worn by Metropolitan Police Department officers would also be redacted by body-worn camera footage, as the police officers themselves also had a high expectation of privacy, although they were acting in their official capacity. So in addition to that, MPD said that they can't release images or interviews contained in a police record of someone other than the requester without authorization from those. individuals and their legal representatives. So in other words, the requester, the MPD was basically telling the requester, sure, we can release anything that shows your face, or your voice or whatever, but anyone else in the camera whose faces or voices could be heard, we could redact those things. So in looking at this case, the director had a few things that she had to determine. Okay. Uniformed police officers, when they're performing their duties, they do not have a privacy interest applicable to DC FOIA Exemption 2. And remember, this was the last argument that MPD made, is that they would also redact the badges of the police officers. Well, a previous advisory opinion that was issued by this office simply held that MPD police officers don't have an expectation of privacy where FOIA is concerned when they're performing their duties in a public place. So MPD's redaction of police officers' faces, badge numbers, and other information that would identify the police officers does not have a basis in DC FOIA. Further, there's no apparent public interest in an unredacted faces or audio of the third-party witnesses sufficient to counter their privacy interests. So, in other words, the requester had not shown anything beyond, had not shown anything that would outweigh the privacy concerns of the other individuals who were in the body-worn camera footage of the MPD police officers. So, even on a public street, okay, third parties recorded on a body-worn camera video, they may actually still retain some of their privacy interest under Exemption 2, depending on the facts of the case. There was no apparent public interest in the unredacted faces or audio of the third-party witnesses that's sufficient to counter their privacy interest. So the same argument. A previous advisory opinion also stated that the validity of MPD's redaction of third-party faces from body-worn camera video footage depends on the nature of the activity recorded by the body-worn camera. So, like most of these things, they're very strongly fact-based. You have to look at the facts in each one of them. There's no broad stroke that you would apply to every single FOIA situation where body-worn camera footage is concerned. And it goes on to say that if the passerbys witness wrongdoing, their privacy interest actually increases, and withholding under Exemption 2, especially if limited to blurring their faces, is more likely to be justified. So, in other words, witnesses to any kind of wrongdoing, well, obviously they have an interest to not have their faces and their voices put out there, particularly by people who simply want to get footage for their own personal needs or whatever. So basically, the rights of privacy and the expectation of privacy increases depending on the facts of the case. There's no apparent public interest in their unredacted faces or audio of the third-party witnesses sufficient to counter their privacy interest. Once again, third parties have a greater expectation of privacy in their voice recordings as well, even on public streets, because voices are not audible, they're not identifiable from afar as faces are. So, in essence, once you have you already have the expectation of privacy based on your face, but there's also an increased expectation of privacy where a voice is concerned, because voices are unique characteristics of people. So in this case, the requester, who's the person who was actually hit by the driver, was seeking video footage, which also included audio, which may carry a tighter expectation, higher, I'm sorry, I said tighter there, higher expectation of privacy due to its smaller range. Okay, and it goes on to reason that by saying that one expects one's voice, even on a public street, to remain audible to only an immediate radius, to people who are close to you, as opposed to one's visual appearance, which at least during lit conditions is apparent from much farther away. So there is an expectation of privacy that if you are speaking you're speaking to someone in close proximity to you. So there's that expectation of privacy that what you are saying is private and it probably should not be disclosed to just anyone, as opposed to your face, which can be seen reasonably with someone with vision better than mine from quite some distance. So the request to receive the entire footage of third parties, albeit with their faces redacted and blurred. So the director states in her opinion that the mere blurring of civilians' faces does not encroach on any apparent public interest because the requester does not allege any relevant additional factors, such as a third party being a government employee in their own right or some other public figure. And certainly without getting into too much of that, there is a lessened expectation of privacy by government employees. You work for the District of Columbia government, you're acting in your official capacity, then there is a lessened expectation of privacy, certainly when we're doing so. Again, that's a whole nother subject for a whole nother time. But essentially, the people who were in this video did not have that particular issue. They were not government employees. So there was no need for their privacy issues or their expectations of privacy to be avoided. So in summarizing this case, citing previous OG advisory opinions that the director has issued, the primary purpose of Exemption 2 of the FOIA, of DC FOIA, is to prevent citizens from being associated unwarrantedly with alleged criminal activity. Okay? Where requested footage includes video and audio third-party footage, who are witnesses or victims to a graphic situation that may lead to litigation, if not criminal charges, then that privacy interest is even higher. So in this particular case, the driver witness retains a predominating privacy interest under DC FOIA. Now, since the driver in this case may become a witness, may become a defendant in the future, she had a heightened expectation or a heightened privacy interest in the body-worn camera audio and video footage. Another one of the things that MPD wanted to throw into this mix in order to justify not releasing a certain amount of footage, they have a general order number SPT-GO-204.05. That order in states that some DC FOIA exemption must be used whenever it's applicable to withhold public records. So if there is some situation whereby MPD believes that some type of public record, in this case body-worn camera footage, has to be withheld, then this particular order, in their opinion, said that some exemption must apply, okay, as opposed to it being discretionary. So to clarify that, DC FOIA does not mandate that an agency withhold any public records subject to an exemption. Okay, it states that certain matters may be exempt from disclosure, and it says shall be exempt. It doesn't say shall, or it doesn't say, shall be withheld or shall be exempt. It is discretionary and it is fact-based. So the director concluded in this particular case that DC FOIA's privacy exemptions do not support the redaction of faces or badge numbers from on-duty police officers in uniform. As for the third parties and the driver herself, because the requester had not articulated a public interest in disclosure that would overcome their privacy interest, and the director concluded that MPD correctly applied its discretion to withhold under exemption number 2. Okay. Right. So that was our MPD body-worn camera footage, which was a FOIA case. This is another Freedom of Information Act case, the deputy mayor for planning and economic development under the Freedom of Information Act. So the requester in this case wanted the Office of Open Government to evaluate um, a situation regarding the deputy mayor for planning and economic development. Call them DEMPED. We use a lot of acronyms in OOG, and you'll probably hear me use quite a few here. A denial by DEMPED of a request by an individual for public records under the Freedom of Information Act. So the question that was presented in this particular case was, may an agency justifiably deny a DC FOIA request when the agency's information technology system would be disrupted or disabled by the process of reviewing emails that the agency received from the Office of the Chief Technology Officer? So the requester's original request had very a lot of parameters, and I'll read it so that you can kind of get in. You can read along with me to kind of get a feel of what we're dealing with here. The requester wanted one copy of every document, email, or audio recording to or from the director or the acting director of DEMPED, and one copy of every document, email, or audio recording to or from any staff members of DEMPED between 01/01/2022 and 11/29/2023, containing any of the following: 5625 Connecticut, Square 1866, Square 1866. As you can see, all the dots, and you can read these advisory opinions yourself. You can go into our Open Government website. There's a listing of all of the advisory opinions that have been published, and you can read for yourself what all those dots are. And it wanted all of these things, including all attachments and the main body of the email. So you get the point in terms of how extensive this particular request was. So DC FOIA provides a right of access to public records and requires a reasonable search, but it limits an electronic search for records if it would significantly interfere with the operation of a public body's electronic system. That's under DC Official Code, Section 2532 A2. For the DEMPED case, tell you real quick, someone just asked me, it is OOG -2023 -006 _ AO. So DEMPED conducted a search. A search is a term of art, and it has a specific definition under the relevant statute, which is section, I think it's 2532A2, when DEMPED's FOIA officer attempted to retrieve all the files that were provided by Octo. So DC FOIA requires a public body to make reasonable efforts to search for records and to attest that a search for those documents was reasonably calculated to discover the responsive documents. And certain case laws, you can see Weisberg versus Department of Justice, certain case law supports this. It also says that agencies are required to conduct a thorough, good faith search for records under a separate case law. There we are. And my thing here is in the way, if it's anyone else's way, as it is in mine. Okay. Other facts that needed to be considered. So significant interference. Okay, and you've heard me use that term when we talked about situations in which an agency or a public body may deny the disclosure or the issuance of certain record requests. Significant interference occurred when DEMPED's IT failed when the FOIA officer attempted to use an application to review the files provided by Octo. DEMPED, the FOIA officer for DEMPED attempted to narrow the search to work with the requester to facilitate the production of the records, but the requester refused to narrow the search. So then the FOIA officer then attempted to fulfill the request as it was requested by the requester And by doing so, it caused an actual disruption of the agency's system. The case law regarding that says that a public body is not required to undertake a reasonable search of the electronic records if the search would significantly interfere with a public body's automatic information system. However, it is the public body's burden to prove that such an interference exists. So, yes, a public body does not have to undertake, it does not have to undertake such a search if in some way it is going to be detrimental to the IT system. But they have to actually prove that it was detrimental to the IT system and that significant interference did occur. So the director also said in her opinion, she said that DMPED should have conducted the search that would yield the results of the request, even though the requester insisted on specific search terms. So in the previous case law that we just took a look at, Pinson, the court made it clear that an agency does have the responsibility to conduct a search that's most likely to yield the records requested. And there are two instances or two cases where agencies faced with a burdensome search, they can resolve the issue by conducting a search for records in a manner that's deemed most appropriate. In one instance, when an agency has conducted numerous searches, you see the relevant case law there. But in other words, when an agency has actually conducted many searches, has done its due diligence, has done the good faith requirements, and has undertaken a reasonable search, and has done so more than once or multiple times, then the court has deemed that, hey, that in such a situation, the court would deem that a reasonable search had been conducted. In the second case, when an agency conducted a broader search that produced the record sought. So it's really about, and for your FOIA officers out there, and oftentimes, you're going to get requests that may not always be simple requests, but you as a FOIA officer have to be able to understand the nature of the request, and if need be, conduct a much broader search in order to produce the records that the requester is seeking. So again, in a situation like that, then it would be deemed that a reasonable search was conducted. So in essence, DMPED was not bound to use the specific terms of the requester, as I just said, in order to execute a reasonable search. And it also goes on to say that it should have conducted a search that would most likely yield the results that the requester was seeking. I think the thing to remember in these situations is that, oftentimes people are not, we kind of joked a little bit about all of those terms that the requester had put into its request. And oftentimes those things aren't necessarily malicious. People are just concerned that they would get everything that they think they need. And so they become sometimes overly inclusive with the terms that they think would yield the results. So that's the reason why I have, being an experienced FOIA officer, being able to look at the request and make your own determination about what is reasonable, whether you need to be broad in what your search is going to be, as long as it is reasonable and taken under good faith, then, hopefully everything will work out and you'll be able to actually gain the documents that the requester is requesting. So in this case, the director concluded that in this instance, DMPED correctly denied the request as unreasonable because the review process actually did disrupt its information technology system. But she goes on to also say that when faced with a demand to conduct a specific electronic search, the agency is not bound by the specifics of that request. The agency's FOIA officer should instead conduct an electronic search that will yield the records the requester is seeking that will not compromise his own systems. Okay. So our next case for review is Aston Community Advisory Team. This was an Open Meetings Act issue. And the request was this. We were asked to evaluate whether an entity created by a District of Columbia government agency, in this case, the Aston C8, we'll call it. We'll say Aston Cat. Like I said, we use lots of acronyms here, and this is the last class of the day. So let's have fun. So Aston Cat is a public body subject to the Open Meetings Act, and that was the question. So, as defined by and contemplated by the OMA's definition of a public body includes a government council, including the Council of the District of Columbia, board, commission, or similar entity, including a board of directors of an instrumentality, a board which supervises or controls an agency, the board of trustees of a public charter school, or an advisory board that takes official action by vote of its members convened for such purposes. In the past, OOG has issued several advisory opinions, which have applied a broad scope to the definition of a public body under the OMA. One of those has been task forces, and the other has been bodies beyond boards or commissions that have an intention to impact district operations and inform policy. Now, these entities meet to consider, conduct, or advise on public business. And you see the relevant OOG opinion that was rendered in that case. So this interpretation applies even when the public body was not established by a mayor's order or a statute, but less formally by a subordinate office or agency. So in this case, if it is a public body that's not directly established by the mayor, but that body itself establishes another body that conducts business, District of Columbia business, then that grandchild public body, so to speak, of the mayor may be subject to the OMA. So the pertinent facts in this case is DHS's interim director relayed in a memo to a council member that DHS will work with the Community Advisory Committee to discuss progress and ensure success of a particular project. And it went on to describe the composition and the function of the Aston CAT. That particular committee was established. It had 15 team members total. 4 of the 15 were based on Advisory Neighborhood Commission membership or an appointment by an Advisory Neighborhood Commissioner. Now, this is significant in this case because ANCs are specifically exempted from the OMA. They have their own statutory openness requirements. That's under DC Official Code 2-5743F. Two of the members are either the presidents of or designees of their local association. 3 members included the ward council member and 2 of the ward council members' community designees. Now, this is significant because, as we said earlier, although the DC Council is specifically included within the Open Meetings Act, the council, it also says that the council may adopt its own rules to ensure the district's open meetings policies as established in 2-572 that is met with respect to council meetings. So while it is in the statute for the DC City Council to be under the Open Meetings Act, there's also provision that the DC Council may enact its own Open Meetings Act laws, which they have. 3 of the members are representatives of the mayor's office of DGS and DHS representatives from district agencies. Now, again, this is significant because normally neither a district agency or instrumentality nor the mayor's cabinet are subject to the Open Meetings Act. 3 of the members represent stakeholders for homeless services who have no particular relationship to the Open Meetings Act at all. So you had sort of this mixed bag of OMA subject and non-OMA subject members. So in a situation like that, well, what do? Well, the director said that in the aggregate, the Aston CAT represents a group of stakeholders brought together for the purpose of discussing progress and ensuring success of a project. So the membership of the Aston Community Advisory Team is specifically designed to include all relevant stakeholders for the purpose of perspective and representation, as well as the ability to interface with the public, and therefore is a public body according to the OMA definition of the same. So another discussion is whether Aston CAT meetings are meetings as contemplated by the OMA. So as you've heard our attorney advisor, Brandon Lewis, he talked about Open Meetings Act. A meeting is any gathering of a quorum of the members of a public body at which the members consider, conduct, or advise on public business, including gathering information, taking testimony, discussing, deliberating, recommending, and voting. So in that same memo, DHS's interim director relayed that the functions of the Aston CAT would be to provide feedback on concerns related to residents' quality of life during any building or repurposing, construction, and during the first 2 years of operation. Also to coordinate opportunities for community feedback and input on all issues and concerns related to the development of bridge housing, and to share information with DHS, and 3, to develop good neighborhood agreements. So that aforementioned activity is business covered by the OMA. The membership includes representatives of public bodies whose own activities are subject to the OMA. And 2, the Aston CAT will provide and coordinate feedback from the Aston residents and the community, report on impact, and to develop good neighbor agreements. So public business. Is this public business? Well, that's kind of hard to say, and maybe not. The receipt, coordination, and provision of feedback functions could arguably be activities that fail to meet the threshold of public business as it is stated in the Open Meetings Act. So on that particular prong, maybe it doesn't meet that requirement for it to be considered a meeting. Or a public body, I'm sorry. Public business in this regard, probably for sure. The development of good neighborhood agreements. During one of the meetings of the Aston CAT, certain protocols were described, and those descriptions were to identify topics, concerns, areas of emphasis, which included property maintenance, safety and security, conduct, behavior, and mutual respect, stakeholder communications. Now, protocols and purposes like that clearly implicate multiple types and gradations of public business, including input from the community, including gathering information, taking testimony, discussing, deliberation, and these are items that are specifically articulated in the Open Meetings Act as public business. So in this particular case, the director concluded that without regard to whether these good neighbor agreements were binding or not, the purposes for them were clearly public business, and the types of activities to which the definition of a meeting under the relevant law was written to include, and therefore the director regarded Aston CAT and other comparable community advisory teams as public bodies that are subject to the Open Meetings Act. So our last and very short case here is also an Open Meetings Act case. And as I said, not everything that we get, we actually have to act upon. And there are certain reasons why we don't. In this case, there was an evaluation. They wanted us, the requester had asked us to evaluate whether a request by a confidential complainant that an ANC violated the complainant's right under the First amendment right under the Constitution of the United States. That is a quote. That's how they wrote it. So I'm reading it how they wrote it. The pertinent facts in this were very simple. The complainant had alleges that the advisory neighborhood commissioner told the complainant, a public meeting attendee, who was attending a public meeting at the time, who submitted a question in the Q&A section during a Zoom meeting. And the advisory neighborhood commissioner told this person, this requester, responded that anonymous questions would not be entertained and that participants would be required to enter a name if they wanted a response. So, of course, the requester felt that their First Amendment rights had been violated, and they came to the Office of Open Government for some type of justice to be rendered. But as powerful as our director is, the director of Open Government does not have jurisdiction over ANC meetings, as discussed earlier. As discussed earlier in this training, such meetings are specifically excluded from the Open Meetings Act, and therefore that particular case was dismissed. Under a different provision, the DC municipal regulation, the legal staff at OOG, we reviewed the complaint and recommended dismissal due to OOG's lack of jurisdiction over the question. Specifically, the director has no jurisdiction over ANCs by virtue of ANC's exclusion, specifically as a public body as anticipated under the OMA. And the merits of the complaint, therefore, were not even considered. ANC meetings are subject to their own open meetings laws pursuant to DC Official Code 1-30911, which are called the Sunshine Act laws. But those laws are not enforced by the Office of Open Government, and this law provides a private right of action to DC Superior Court. So that concludes my presentation regarding recent advisory opinions that have been issued by the Office of Open Government. I want to thank you all for your participation. I don't see any particular questions right now in the box. I don't see any. But if there are, please feel free to send them to Open Government Office at dc.gov, or you can reach out to myself or any of our colleagues, and we'd be happy to answer any of the questions that you have about those cases. But again, you can go on Open Government website and you can see a copy of all of the cases and all of the advisory opinions that the director has issued regarding Open Government or FOIA. So thank you all very much, and I hope you all enjoy the rest of Ethics Week and have a wonderful day.